Welcome to another week of Available Work. We're going to get right into it. It's attorney topic day today.
Woohoo!
We've got our rambling band of attorneys, our employment law attorneys, fresh off of Denton. Our Texas Conference for Employers in Denton was last Friday, right?
It's true. It was great. It was great. Great group
Awesome
in Denton.
conference.
So Elsa, Mario, Jakku's on line 5, Katie's on line 5, and of course, welcome back, Bonnie.
Hello. Y'all invited me back. Thank you so much.
What's new, Bonnie? What's been going on?
I have some hot off the presses news. Texas was just ranked yesterday the best state for business for 21 years in a row. I think we need to give a
Not
round of
surprising.
applause for that.
Yay, Texas.
21
Texas.
years.
Not surprised.
And this is from Chief Executive Magazine, and this is based on their annual survey of the nation's leading CEOs. So they took a survey out, I think it's over 650 plus CEOs across America, and they anonymously said that Texas is the best state for business.
How's that different than the hardware? We get a big trophy every year.
Right. The Governor's Cups is based on projects,
Governor's
development
Cup.
projects. Right. This
Okay.
is a survey simply given to CEOs across America. And culturally, I just want to say 21 years ago, Facebook was just launched, and we were 3 years before the iPhone, which was 2007.
We're all better for it.
So I just think it's so neat. 21 years ago, Texas started to be number one, and here we are. We've made it through
No kidding.
a lot and continue to lead the way. So
That's
just
interesting.
fun news
So
there.
this was decided among CEOs. So CEOs even not located in Texas.
That
We're
is
talking about
correct.
People just doing business with Texas and potentially wanting to move their businesses to join the party.
It's great news.
Why wouldn't a CEO want to be located
right.
in Texas? We'll have to bring one on to find. We'll have to find one. I think that's what we're going to do, Katie. We're going to find one and bring them in and ask them, why don't you want to be here, and see if we can
We can make that
change
work.
their mind. Yeah. Our attorneys audience, again, probably one of the best resources that our office provides is our attorneys as far as guidance to employers. So this is going to be a series of topics that we want to discuss. Mario, Jakku, Elsa are here today, and then once you defeat them, you get the final boss, which would be Tommy Simmons. I think we're going to give him his own. We're going to give him his own sit down, and we'll have these recorded. And like I said, we're going to cut these up to where you can. And I really hope you found us. If you found us and you're listening, because it might be a topic. But also, what are we talking? What is the topic you're going to bring on today?
I'm going to talk about how employers who fire someone,
Okay.
what they need to prove to win the unemployment claim.
Okay, so separating somebody from your business, if that's something that you as a listener, or maybe you found us because you're agonizing over what's the proper way to doing this. I do this a lot. Sometimes if there's an interesting topic or something going on in the world, I'll put it into your Google machine and find a podcast where you can find an expert talking about it and kind of go from there. It's almost, podcasts I think are almost kind of the first, other than your Google search, but a good conversation of a living person. I know a lot of these are in AI now, but I mean, like I said, so yeah, we have your expert here from the Employer's Office at Texas Workforce Commission talking about some of these topics. Mario, what are you going to get into?
So I'm going to be doing something similar. It will deal with unemployment claims,
Okay.
but instead of the worker being fired, instead in my topic, the worker will have quit the job. So we'll
Okay.
talk about some things that go on with unemployment claims where the worker has quit the job.
Yeah. Okay. So yeah, these topics kind of lead into each other. It's kind of like your daily brief of business when it comes down to how to run your business and keep your workforce happy and moving right along. And Elsa, you like to say free money when it comes to stuff like this.
Yes,
What we're trying to do
everyone
is
loves free money.
keep
What
you
we're
from-
trying to
Yeah.
do is save you money.
So the big bite of the apple would be, and I mentioned earlier, y'all just came back from Denton on
Yes.
last Friday.
Yes.
Jakku, y'all ate at Cheddar's this time around, right?
Yep.
Okay, yeah. The lunches and the dinners were at Cheddar's up in Denton.
In
but
Denton, yes.
we're going to be talking to Jakku later, and he's going to tell us his favorite chicken fried chicken.
He has been doing the chicken fried chicken tour of Texas for the last 2 years.
He is an expert not only on the ADA that he'll be talking about, but also on the chicken fried chicken, across
Great
Texas.
segue. Yeah, way to set him up. That's great. But that Texas Conference for Employers, what can y'all tell us about what goes on at these Friday events and sometimes 2-day events? I think our big one this year is going to be in Dallas.
Elsa, do you want to kick off on that?
Yeah, please.
Yeah. So this is a conference, educational seminar geared towards small, medium employers, people that do not have HR professionals or legal counsel on their staff. So if you have any questions on how to pay your employees and how to hire employees and whether you should have policies and what happens if I need to fire someone or someone quits me and what's my liability. The nuts and bolts of employment law, if you're a new and small to medium employer, you can learn that at our conferences for sure. But even if you've been in business longer, it's great for new employers, but even if you've been in business longer or if you have new HR people in your company, bring them in, send them to us. Because I've said this before, but what you do not know can cost you.
That's right.
And to that, I would add that in addition to what Elsa just mentioned right now, at these conferences, we also have exhibitors from a lot of offices from state agencies, such as the Texas Workforce Commission. We'll have like a Civil Rights Division booth that's out there, and also the tax department that's out there as well, along with things like labor market, career information. So these are other resources that employers can also take advantage of while they're getting educated about the nuts and bolts of employment law. So that's another aspect and another benefit of attending the conference.
And I think, too, another aspect and benefit is you're networking with other businesses in your community as well, right?
Yeah.
Making those connections, meeting your community. And I think that's just something that you usually don't get outside your business to do. So it brings everybody together.
Good point. Yes, it
That
does.
and the resources from other state. We invite our local workforce solutions board so that you can have a handshake with them. And then we just basically integrate most of, all of the state resources that we can provide. Insurance, our insurance folks come around. Our veterans, we also do
Yes.
some big veterans topics there too.
OshCon, Texas Department of Insurance, they're there too. So a lot of different resources for employers.
Sometimes the U.S. Department of Labor is there as a resource. So
Oh, yeah. Well, thank you to those folks out there. Just kind of, thanks for all of our partners that come in and continue to educate our employers. But do you got anything?
No, I just kind of wanted to maybe dive in and Elsa kind of walk through with us, step by step. Say you're an employer and you get the notice in the mail that, someone has filed for unemployment. How does that start and what steps or tips can you give them for success?
Okay, so great question. Big question. So I'm going to take it back just a little bit for those of our listeners who did not listen to our unemployment podcast, sort of the basics. Let me just very quickly let you know that if you separate from your job in Texas, you're going to be qualified for unemployment benefits unless it's your fault. The system is fault-based. And I'm going to be talking about terminations initiated by the employer. Because employers, this is a job separation, using the jargon,
Lingo.
the lingo.
Lingo.
This is the job sep where you have all the control because the decision is yours. If you're going to fire someone, this is on you. So you get to choose. So to Bonnie's question, when you get the notice of claim, basically what you need to do to win the claim, at that point it might be too late to do what you need to do to win the claim. So you need to be ready while they're still working for you and get your ducks in a row, as I like to say at the conference, get your ducks in a row so you can be ready for after they leave you, okay? So you get the notice. What do? At that point, you respond. So
Is that
so
one?
many things.
I
so
feel
many
like
things.
that's a common mistake. People do not respond.
People do not respond or they do not respond timely
To the note, just to the
to the notice of
basically
claim.
the notice that somebody is filing
Protect
to
your
get
rights.
benefits. Okay.
And there's different kinds of job separations. There are layoffs. There are people that work for you PRN as needed, so you don't always need them. There are people that work for you seasonally. At the end of the season, they're no longer working for you. But employers need to know that if somebody stops working for you, they don't have the option to continue working for you. You, the employer, initiate the job separation. That person is going to get unemployment benefits unless you can show it's the employee's fault they're out of work. And what you need to show that it's their fault is legally misconduct connected with the work. That's what you need to prove. So we'll get back to getting that claim notice, but right now you need to prove misconduct connected with the work. There's a legal definition for that. We're not going to go into it. In broad strokes, how we simplify it for employers is you need to prove 3 things to prove misconduct. You need to prove a final incident of bad behavior in the employee's power to control. So bad behavior in the employee's power to control.
Can you give an example of that?
Sure, somebody violates your attendance policy by being tardy all the time. That is in my control, being tardy.
For personal reasons.
Yes, for personal reasons, not because the employer's like blocking the door or whatever. That's a different thing altogether. But any violation of a work rule or policy is in my power to control. Me getting my work done is in my power to control. Me following instructions is in my power to control. Basically, what you need to do to get the work done, if it's a reasonable employer request and I'm capable of doing it, I do it. If I don't, and that's in my power to control. Things that are not in my power to control. I like to bring up, for example, sales. If Bonnie, I say you need to sell 20 widgets, and you're like, I did my best, I tried, I couldn't sell, I only sold 15. Is that all in your power to control? Normally it's not, because you have the product, you have the pricing on the product, you have this time of year, you have the region, you have all these other things that may affect your sales. But if the employee is doing everything the employer says the employee to do, you're calling all the people, you're making all the appointments, you're writing all the reports, you're following the script, all of that. If the employee is doing all of that and can't make the sales, you need to let them go. That's a business decision. That's not going to be misconduct because they've done everything you've asked them to do, and the sale is not in their power to control. But if they're not doing everything, they're not following the script, they're not doing the 10 calls per day, they're not going to the appointments, they're not doing the training, they're not doing the follow-up report, then those are things that are in their power to control, and that affects sales, then that could be misconduct connected with the work. Did I make it more complicated or easier to understand?
It's understandable.
We're nodding.
Yes.
We're nodding.
And
Yeah.
Could you go over the three the three things that employers need to meet again?
Yes, so you're going to want 3 things to prove misconduct connected with the work. A final incident of the employee's bad behavior that happened close in time to the
That's
discharge.
what I was going to get at.
Yeah.
Right.
And that the employee knew or should have known it was going to cost them their job.
Okay.
That gets you to misconduct. So you have to prove my bad behavior that I can control. Don't pick something from 3 months ago you couldn't get over, employers. Pick something, some employers delay firing someone. It's like they say, this is bad. Oh my gosh, this was so bad. But you know what? It's crunch time. I really need that body. I don't want to let go of this person. So you keep them for the next 60 days to get through crunch time. And they're like, okay, now I'm going to go back and let them go. That's completely fine and legal. But if you delay too much, it's no longer going to be misconduct connected with the work because now you're letting them go at the employer's convenience.
I think I've heard y'all say, hire slowly, fire quickly. Is that a...
Probably not that phrase, but yeah.
Okay, never
heard
mind.
that
Take
somewhere
that
else.
back. I did hear that somewhere else.
Heard
You
it
did hear that
somewhere.
Well, or just maybe not, taking that word by word, but if you fire someone, don't wait on it.
Right.
You know.
I think what we see a lot of are people almost employers making a list. They're like, okay, this is I'm going to have a huge long record of things that this person has done.
Yes.
That when I finally am
Yes.
able to do it, I can show them all. Like we can show all this. Like,
Yeah,
is
yeah.
it good to have a record? But still, you have a trail of performance that continues. Does that just mean that the employer is okay with that person working at that level?
Not necessarily. So ultimately, you need all the straws for the employer to get to the point where, like, you know what, I'm done with this person. They're just not doing what I need them to do. I gave them so many chances, like Commissioner was saying. I'm keeping track. I'm doing all of these things about their bad behavior. But at some point, there's a final straw that gets the employer to decide to fire somebody, to terminate, discharge. Those words are interchangeable. That final straw has to be misconduct connected with the work. So very important. The first straw, the second straw, the third straw could have been really serious and misconduct on their own. But when the employer chooses not to discharge for those, we don't count those. The final incident, the final straw, yes, you needed all the other ones to get to that one, but the final straw has to be misconduct connected with the work.
Okay.
TWC is going to focus on that final incident. So that has to be bad behavior in my power to control that happened, close in time to the discharge.
And is that something the employer can tell the employee verbally? Like, I told you needed to be on time, or I told you needed to, not take 2-hour lunch break, or does that need to be written down somewhere? How does that
Yeah,
tie
so
in?
we get questions.
Jakku?
We get
Was
questions.
this a
Is that
Jakku-
Jakku's
this
topic?
No, I
Am
don't
I
think
jumping
so.
ahead?
But I think it was our past episode was employee handbooks.
Yes,
yeah.
I know that's very important.
Yeah, so we get questions from employers. How many warnings does TWC
Oh,
need?
yeah.
Let me break it to you. Let me let you know behind the curtain. TWC doesn't have a rule on how many warnings before letting somebody go. So to Bonnie's question, should I tell them? Absolutely, because remember, you need to show that the employee knew or should have known. That's one of the 3 elements. Employee knew or should have known he or she was going to be fired for that behavior. How do you get to that? Verbal warnings, written warnings. Nothing wrong with verbal warnings, okay? Except they're very easy for an employee to refute. I was never warned. Yes, you were. I warned you. Like, I don't remember that. I remember you talking to me about a training issue or, something like that.
That happens.
But I did not know that I was going to, that my job was in jeopardy. And that's what the employer needs to show, that I knew it was going to cost me my job the next time I did something. Written warnings are better. Not required. The burden's on you, employer, to prove those three things. Final incident, closing time to discharge, and the employee knew she was going to be fired. Written warnings are not required, but they're better because if it's not written down, it didn't happen. Much harder for an employee whose signature is on that written warning to say, I did not know it was going to cost me my job.
And what if you have an employee that will not sign that?
What if you have an employee that is
that
a
happen?
lawyer?
That was, no, I think it was pretty topical.
Yes.
Pretty relevant today.
Yep.
Yeah, who does not want to sign? That's fine. So employers have different avenues for that. I believe it was Tommy Simmons who said, and this is brilliant, have two signature lines. One that says, I agree with this warning. This is a cost of admission here. You just made money on this. If you can, prove an unemployment claim or prove misconduct in an unemployment claim. Two signature lines. I agree with this warning. I disagree with this warning. People are likely, look at Commissioner's face. That's smart. People are likely to sign, I disagree with this. And have an area for employee comments as to why they disagree. If they don't want to sign either one of those, okay, I'm going to write down, refuse to sign. Could you please initial that you refuse to sign, initial and date? People will do that because it doesn't matter to us, to TWC, whether they agree with the warning or not. It just matters that they were aware that their job was in jeopardy. That's all you're trying to prove.
And if the employer has the luxury of doing so, they might consider having a management side witness in the room while they deliver the warning to the worker. That way, in the event that the worker doesn't sign, there are two employer witnesses that can provide written statements or later testimony if it gets to a hearing that, hey, look, this is the way things went.
Yeah. The employee was there. The employee was told. They refused to sign. Unfortunately, a lot of small employers don't have management, or enough employees to do that. And they don't want to bring in somebody who's at the same level as the employee who's getting reprimanded to come into the room. And if all else fails, can you record the disciplinary meeting? Texas is a one-party state.
Yes.
So you can record it by telling the employee, hey, if you don't mind, just to have a record of this, we're going to be recording this. Wonderful. They don't have to agree to it. You can record it. And legally, you don't have to tell them you're going to record it.
Right. As long as one person in
As
the
long
room
as
knows
one person
it,
in the room
recording.
knows. So most employers don't go to that, but we have been seeing more and more cases of employees showing up with recordings of the termination meeting as well. So as long as you let people walk in with a phone, just kind of think that they may be recording it.
Have you ever seen an employer win a case without those three
Sometimes.
items? Or, is that they need to have one of two, two of three, or none, or all of the above?
It's like a Meatloaf song, 2 out of 3.
Don't get me start singing here.
For those of you, Meatloaf is a singer. That goes back a minute. The burden is on the employer to prove misconduct. So employer, it's on you to prove that the employee committed these acts or whatever the final incident. Like you said, a 2-hour lunch after told you only can take a 1-hour lunch. Coming in tardy again, leaving early without permission, not getting the work done, not paying invoices, hiding stuff in their desk, or, you find little bottles of alcohol when they go on vacation. You go through the drawer because you're sitting at their desk. Yeah, that happens. And you find that this is going on. So you need to prove it, and it's on you to prove it. But oftentimes, a claimant, and that's a person who files a claim, the claimant will self-disqualify. So they will say, yes, I did that, and then try to have an explanation. But that gets you there. So do you, as the employer, need all of those things? Those are the things that need to be proven. So you do take a risk if you don't have all of those things. It's like, oh, it was 6 weeks. I waited 6 weeks, but I was doing that. We had really good reasons why we waited 6 weeks. The person was on FMLA when we discovered when they were out that they were engaging in this activity. So we needed to wait for them to come back. So, okay, not close in time to when you discovered it, but there's a really good reason why. So everything's on a case-by-case basis.
Yeah. And generally, the employer shouldn't bank on the claimant just admitting to the bad activity.
No.
That probably does not happen.
That does not
too
happen
often.
very often at all.
So really can never have enough evidence on the employee.
It's better to err on the side of having enough evidence or evidence that you end up not using. It really is, if the unemployment claim matters to you.
Right. And it's kind of like what Elsa had mentioned earlier, since the employer is the one initiating the job separation, it's them that has something to prove, and so having those elements is kind of part and parcel with providing a case, providing the information as to why the claimant needs to be disqualified. And so if the employer doesn't show that, they're going to be in a challenging position on the unemployment claim.
Yeah, this is a legal case. It is.
And this all unfolds in our appeals and our appellate process.
Yes, all internally, all in-house. And employers, you don't need lawyers. You don't need to spend money on lawyers. The system is set up so you can represent yourself.
That'll be good. Aside from, you mentioned earlier that you answer the request.
Yes.
Right. Are you able to check in, and what does TWC provide with that request or with that notice when it comes down to? Is that the time where a hearing has been set?
Okay, so good question. So first step, you fire or you choose to terminate an employee. Employee files an unemployment claim, and because TWC doesn't do anything in the dark, we give notice about everything. The employer is going to get a notice. And that's the first time that you can protest or say, I don't agree with, Elsa getting benefits because we fired her for taking extra long lunches after warning. That was misconduct. She knew this was going to happen. And you get to respond. So it's really important that you respond. It's a 14-day deadline, so it's a short period of time to respond. But you can call it in. It doesn't have to be in writing.
Okay.
It doesn't have to be a legal paper. You don't have to have all your documents in. If you do not think I should be getting benefits, again, this is different from a layoff or something else due to lack of work, but it's for misconduct, respond within the deadline. Mail, fax, online, if you are set up through our employer benefit services system online, or you can call it in. Heck no, Elsa should not get benefits. We fired her for misconduct. At that point, an investigation happens, and TWC, in a short period of time, decides whether or not me, the claimant, is going to get benefits or not. And another notice is sent, right? Because we do everything out. Everybody, we don't hide the ball for anything. Another notice is sent. At that point, if it says that I'm getting benefits, that you are losing, you're being charged back for benefits, then you get to appeal that. Short deadline, 14 days. Definitely appeal that timely. I cannot express how important it is to be timely with your appeals and your responses, because the easiest way to lose a case is to not be timely.
I was going to ask, what happens if you miss one of those deadlines?
If you miss the first one in the response, you lose appeal rights.
Okay.
If you miss the appeal deadline, once I'm winning, once a claimant is winning, and there's no exception, you can't overcome timeliness, you're done.
Right.
You're done. That's it. It's over.
Employers will have a chance to appeal their loss of their appeal rights, but there are very, very, very finite circumstances that will overcome timeliness. It's kind of like the dragon guarding the treasure. It's like timeliness is that dragon, and it's very difficult to move it if you're not timely.
If you're not timely, yeah.
Love that.
It is.
Yeah, that's awesome. Elsa, thank you. That was unemployment claims and how you can win, our employer, how you would be able to win in case of a discharge.